Good evening. The meeting of the Election Campaign Finance Committee for the Corporation of Mississauga is now called to order. Welcome. I'm Rafiq Okaria, Chair of the committee. Today is 7th February 2012. The purpose of this meeting is to consider an application for a compliance audit. We have one application on the agenda for consideration. Powers of the committee. The Election Campaign Finance Committee exists under the statutory authority of the Municipal Election Act. The committee members were appointed by resolution number 0239-2010 on September 15, 2010. Are there any conflict of interest to be declared by any committee members? No? No myself? No? Confirmation of the quorum. We have a full quorum, 5 members, minimum meeting 3 out of 5. The quorum has been met. And now the committee will proceed with the examination of the application. The application will be considered by the committee. Each committee member will have an opportunity to comment and or ask questions of either the applicant or the respondent. The applicant and the respondent will be invited to make comments. During the course of discussion, the committee may seek legal advice if necessary. Should this occur, the committee may convene in camera. When the committee is ready, a motion will be made to grant or reject the application for a compliance audit. The committee will present an oral decision and a formal notice will be forwarded to the respective applicant and respondent via email. If the application is granted, a compliance audit will be ordered. If application is rejected, the committee will take no further action. The decision of the committee can be appealed through the Ontario Court of Justice within 15 days. The name of applicant in this matter are Mark Cochin and Siegel. Are the applicant present? Can you please state your name?
Mark Cashin, Siegel.
Are the applicant represented by legal counsel?
No.
The name of respondent in this matter is Crombie. Is the respondent presented by legal counsel in this legal matter?
Yes, she is.
Can we, respondent, legal counsel, please state your name, please?
My name is Jack Siegel, S-I-E-G-E-L.
Madam City Clerk, can you please confirm for the record that the application was filed within the applicable time limit?
Yes, it was.
Can you please confirm that the applicant name was an eligible elector in the most recent municipal election?
I can confirm that one of the applicants was an eligible elector.
Can you please confirm that the respondent name was an eligible candidate in the most recent municipal election?
Yes, she was.
The application meets the criteria and may be put before the committee for the consideration. Now we're going to examine the application. We receive your request of an audit with all the submission you provided to the clerk. There were a number of issues were raised, about 6 of them, which is the part 1 of the Summary of Alleged Convention of Municipal Election Act. Can you please walk us through, very briefly, each issue, and you have provided us a copy of the supporting documentations?
Correct.
Just walk us through quickly.
Mr. Chairman, if I may, I have a number of procedural concerns I wish to raise before we start into the substance of this.
Go ahead.
It's my submission that this application is not properly brought for 2 reasons, primarily. It is, in my submission, utterly improper in any proceeding in Canada, judicial or quasi-judicial, and I would submit this is a quasi-judicial process, to relitigate an issue that has already been decided by anybody, let alone by the exact same body. And a number of the issues that have been brought before you here were decided at the previous hearing on October the 25th. For you to do otherwise would constitute, in my submission, an abuse of process of the committee and would establish a very dangerous precedent whereby no decision of the committee is at all final, because further application after application after application can be brought, whether by the same applicants or otherwise. And clearly, in your own remarks that we've heard so far, the decision of the committee is intended to be final and subject only to appeal if an appeal is brought within 15 days. It is my submission that any objection by Mr. Cashin and or Mr. Young, whichever of the two is an eligible voter able to do so, was properly and only capable of being raised by way of an appeal to the Ontario court within 15 days after your decision, at which point that decision should be final and not subject to relitigation. In law, we use two phrases. We use in the civil process the concept of res judicata, that which has already been decided. And the Canadian courts very consistently rule that where the parties are the same, regardless of the tribunal being the same, such a matter will not be heard a second time on the same issues. And the issues relating to the poll and to the lawn signs are exactly the same issues that were argued before you previously. In the criminal justice system and penal justice, it's referred to as double jeopardy. And in that case, there's actually a charter prohibition. It's my submission that these issues, at minimum, should not be permitted to proceed. The second issue relates to the lack of particulars in the complaint. It is a fundamental principle of natural justice that a party is entitled to know the case that they are expected to meet. That means providing sufficient detail prior to hearing to enable a party to respond to the allegations that are to be made at the hearing. There are no facts, no such details contained in the complaint that was filed. Rather, we have what I submit as an attempt at trial by ambush today with a binder that I have not even yet had an opportunity to finish reviewing, raising all kinds of concerns of which my client has had no notice whatsoever. There's at least one issue I have noticed, something to do with the extension that was obtained from the courts. And I don't know how that issue plays yet, but there's no reference whatsoever to any such issue in the material that is being filed. It is my submission that an application to a compliance audit committee is only properly brought if on its face, on a clear reading of that document, it reflects a genuinely held belief on reasonable grounds that a contravention of the Act was committed by the candidate in question. As referred to in the material that was before you last time, and is the material that I've left at your desks and provided to the gentleman beside me today, the Ontario Court of Justice has very clearly set out that the grounds that need to be stated to warrant a compliance audit, and I would submit to permit you to proceed to a hearing properly, are an objective, not a just I say so or I think maybe belief, not speculation, but an objective belief based upon compelling and credible information, not speculation and belief, let alone a complete absence of what's contained in the complaint, which would raise a reasonable probability of a breach of the statute. It's my submission that the complaint before you contains little, if anything, to reflect an objective belief, a compelling or credible information, because all it does is outline section numbers and vague allegations that really can make no sense to a person who is in the position of having to respond. It's my submission that to proceed with this hearing would in itself constitute a denial of natural justice. And I would submit to you with the greatest of respect that the complaint should be down dismissed without further hearing.
Objection to it?
I do have an objection. I think Mr. Siegel has been practicing law for 30 years, 35 years.
Not that old.
25 years. And I do understand where he's coming from a legal point of view. Unfortunately, this process is supposed to be transparent and open to citizens. I think what he's trying to do here is set a bar so high for the average citizen to obtain that no complaint would ever come. No citizen would have any right or even attempt to try and keep democracy in check. I believe he's made a couple of statements with regards to being objective. We believe we have been 100% objective. Did we put all the paperwork in correctly in regards to the standard that Mr. Siegel is trying to set for a citizen hearing? I think we've done the best we can. I believe our evidence is compelling. A lot of it relies on third party, including some of the suppliers that Mrs. Crombie used. So we disagree completely with the standard that Mr. Siegel is trying to set, or a threshold he wants to set before a committee would hear. With regards to the last hearing, although it was heard, the decision was there wasn't enough evidence. It wasn't that there was no merit to any of the issues we brought before you. So to go and appeal a decision that there wasn't enough evidence, I'm not sure how you fight that. But instead we went and got the evidence that we need. Even though he's referring to the penal code and the civil code and many other codes, really what we're dealing with here today is the Municipal Election Act. And we've got to stay within the parameters of that. If we start going way beyond the parameters, no citizen is going to be able to figure out the whole legal system to do what we're doing here today. To talk about money and all these other things, yes, Mr. Siegel does probably charge a hefty amount for his time, and it is the choice of Mrs. Crombie to pay him. It also has taken us huge amounts of time, energy, and costs to print things, etc., our own resources. So to dismiss that as it not costing any money, I take offense to, because it costs a lot of money, a lot of time, a lot of energy. We believe we're doing this because we're allowed to, we have the right to do it, and we need people to do these kind of things to make sure that the system is in check. I would also reference a case from Casamano versus Toronto where they talk about people that are eligible for a binder. No, that's not in the binder. Where they talk about people that are eligible. And, you know, in section 44 it says the final matter concerned has no standing to bring in this application. My pronunciation might be off.
Cusimano.
Cusimano. Yeah, and a place before that shows that good reason to believe that Casamano was not qualified to be voting Ward 9. So dealing with his issue of who has the right. But the judge in the end did say that whether he had the right or didn't have the right, the important issue is whether the election was valid. And to actually go through it and deal with the issues is more important than the technicality of who's making the complaint.
May I have a brief opportunity to reply to the points raised? The fundamental point here is not about the ability of Mr. Cashin and Mr. Young. It is that it is unfair to provide them with a second kick at the can and put my client to the expense and trouble of responding and put the city of Mississauga to the expense of reconvening this committee. It is unfair to the candidate to require her to respond to allegations, details of which she has no advance knowledge of. This is an abuse and it should not be countenanced.
I heard both sides. Your objection to the objection. Just the previous application was the decision we made based on insufficient evidence. At that time, the financial statement was not filed. So therefore, we could not refer the matter to the auditor what to do. I questioned Madam Crombie at that time. She's going to file on November 17. They were due on November 17 by the clerk. The statement was filed. Based on the statement filed, any electoral citizen of Mississauga has a right to file a request for compliance. I see this as a fresh application. Okay, and in applying the law of natural justice, I will hear this application, I'll hear the submission from both sides, and we'll move on from there. That is our decision. So we're going to proceed with the application.
I would respectfully request that this committee adjourn to permit counsel for Ms. Crombie to learn of the allegations that are now being made against her. I have no knowledge prior to walking into this room of the contents of this binder. I am not in a position to respond.
How long do you need?
Hard to say. I haven't read the material yet. I do not know. I'll ask right now for half an hour. But I do not know if at the end of that half hour, in order to prepare a proper response, it is going to be possible that can be done this evening. My client should not be prejudiced by lack of notice of the allegations that are to be raised. And I am expressly, as I have in the written material before you stated, reserving the right to request that tonight adjourn entirely so that a proper response can be prepared.
You want to say something?
Sure.
I wanted to make a point.
Okay, I'm going to object to two people speaking on the other side. There is one applicant who is a voter. There is one application before you. Could we have a single spokesman, please?
No, here is a hand, that's why I asked him a question. This is a meeting, it's not a appeal tribunal, it's not.
I understand that.
It's a meeting.
I'm still asking for due process.
No problem.
Mr. Chairman, my point is to exactly what Mr. Siegel just mentioned. He said there's one qualified elector in the ward. I was a candidate in that election. The outcome of the election affected me directly. The city clerk vetted me as a candidate. I therefore, as far as my interpretation of the act, have a right to bring this, to be a party to this hearing because of the fact that I was a candidate. And I'd like, if it is proper for you to ask the clerk whether or not, or the city solicitor or the clerk, whether I am not party to this and it is proper.
We can address that in a minute. I think we have an adjournment request here for half an hour to go over the material. But keep in mind, your material, appellant material, and respondent material is also new to us, except what the issues have been raised and the letter has been given to the clerk. So we all, you know your material, you know your material. All my colleagues here have two binders, it's all fresh. And I'm hoping that you're going to walk us through, okay, your submissions and your defense, right? If you need time, half an hour, keep in mind that we have room booked till 10 o'clock. So it's going to be very quick, unless we can go another day. If you go beyond 10 o'clock or 11 o'clock, I mean, there's time limit to it. So I'm willing to give you half an hour to go over the material with your client. Okay?
Mr. Chairman, if I
Yes.
just may respond to that. We are also just received his material, the same as he just received ours.
There's no evidence contained in it.
And everything that we are providing is publicly available.
Right. And the matter which you raised, Mr. Young, I will discuss with the clerk and our solicitor as to what, but we have one specialist. So, we adjourn for half an hour, 7:20. We should be back in half an hour. Meeting adjourned. 7:40.
No idea what
It's 10 to 8. We're going to start the meeting, continue the meeting again. Few housekeeping matters. As Mr. Siegel objected, the valid applicant is one person with electoral as confirmed by the Madam Clerk, Mr. Lear, Mark Cashin. However, you have to choose one spokesperson, but you can consult with each other. Okay. So I'd like to know who will be the spokesperson. Mark Cashin. Good. You can ask, going on, please.
Would you like us to start?
You had a chance to discuss the procurement?
I've reviewed the material. My objection is noted. My objection remains that this hearing should not be conducted on the basis of trial by ambush.
We already know on that?
I'm asking that it be noted in the record that I continue to object to this process.
It has been noted.
Thank you.
Mr. Cashin, can you please commence your...
Yes, I will. We will be starting with the preface that we've used our best efforts in gathering the information that we have. We're not accountants, we're not lawyers, we're not specialists in this field. And if there's a change in the tabs, it is marked with, we did our best to mark it on the PowerPoint with red. If there's any...
Just walk us through, you want to show the slide?
No problem.
Plus the binders we have?
Okay, so just to cover what we're talking about, the 41st federal election happened between the start, the writ was dropped on the 26th of March, and financial statements were supposed to be entered by September 1st. Mrs. Crombie, along with other candidates, did get extensions. Where the issue, we believe, comes in is how it crosses over into the same period as a municipal election, which was, she registered August 4th, election September 19th, and then the financials were due November 3rd, however they were extended to the 12th, where we have the overlap of two campaigns. And going through this document, we're going to see that we believe that the assets of the federal campaign were dropped into the municipal campaign. This application for compliance audit has been brought before for the 19th election. The successful candidate, Bonnie Crombie, was granted an extension for her filing of the returns, which is on tab 2 by a provincial court judge, which we can see there. The reasons were also, for some reason, invoices were going to an MP's office. And
I want to object to anything relating to this. It's not part of the matter before you.
What's the relevance it has?
Well, I think two things. One, didn't meet the standard date that everyone else met. And two, I think the reasons are questionable that the extension was granted. But we can move on.
Mr. Cashin, I'd appreciate if you can go through your issues, 6 issues you have.
No
To
problem.
bring us in the same line, issue number 1,
No problem.
where she contravened
Yes.
the Election Act, and if you have any exhibit to show us and walk us through the exhibit, that would be much easier.
Okay, so we're going to, you want to skip the background, or you want us to go over the background?
How long is the back?
6 slides. We can skip it.
Carry on.
You want to carry on? Following review of those returns, there's continued concern with polling conducted by Mrs. Crombie in advance of her registered as a candidate for the above election in contravention of the Municipal Elections Act. In the submission, we will present references to other breaches of the Act, citing excerpts from audited financial returns from the Mississauga Streetsville Federal Liberal Riding Association, financial returns 2008-2011, 2007 provincial elections, and they'll all be referenced. We intend to highlight other concerns to support our findings and documents, transcripts, photocopies, professional estimates, and other related materials, bringing it back to credible evidence. We have included the minutes of the first hearing that was required from the Freedom of Information request. We sincerely believe the grounds to conduct a compliance audit and financial returns to Mrs. Crombie, as she has violated sections of the Municipal Election Act, and so doing may have affected the final outcome of the by-election. A full compliance audit conducted by an auditor with powers set out in Section 33 of the Public Inquiries Act will expand the limited information presented on the standard financial forms. Polling conducted July 18th is where we'll start.
That's the issue number one, right?
Issue number one. In the hearing before the committee, October 28th, Mrs. Crombie was represented by Mr. Siegel, and a factor presented at the meeting was clearly laid out in the committee's task. Consider whether the application reflects an objective belief based on compelling and credible information, which raises the reasonable probability of a breach. So we will go through basically, and we agree to all that, by the way, that it should be that way. So polling conducted during the above meeting, Mrs. Crombie admitted she violated Section 76 of the Act, incurring an expense prior to her
I'm about to object to characterizing anything even remotely like that. That was not what happened. I strongly object to Mr. Cashin putting words in my client's mouth. Her position throughout that proceeding was that there was no violation. This is absolutely unacceptable behavior, and I'm asking you please to rein this gentleman in.
Objection noted. Be precise. You're alleging something. You brought a section of the Act 76. You were saying during her above meeting, Ms. Crombie admitted. Like, in the allegation you support.
Okay, so we're going to be referencing the Section 76. So at the October 25th, the poll was conducted, and you can reference the minutes of that meeting under tab 4. And he references that it was done at a cost of some $236. The poll consisted of the collection through a touch-tone telephone response system. Some 236 is entirely unrealistic and misleading figure for the poll conducted on Mrs. Crombie's behalf. And we submit Mr. Siegel and Mrs. Crombie chose to diminish the value of the poll drastically, understating its cost and thereby reducing its significance. What was also provided on the 25th was a chart showing the rankings of 6 of the most recognizable names from an eventual field of 27 contestants, 5 of whom were registered as candidates for Ward 5 Council at the time the poll was conducted. That's under tab 5. Each of the 6 contestants in the poll were recognizable. Mrs. Crombie was the recent defeated Liberal MP. Mr. Deere was the Rogers Cable 10 station manager, popular local personality. Simmer Kaur was the second place finisher in the October 25th election. Mrs. Parrish was recently defeated council in Ward 6. Thomas was sitting separate school trustee in Ward 5. Rick Williams, the sitting public school trustee in Ward 5. This was not a random poll, rather it ranked recognizable names, all of whom could be expected to attract a block of votes in the by-election. Mr. Siegel presented a single-page document under tab 5, which was a printout from the polling company Solus One. It also appeared to simplify the polling process, showing only 230 completed calls. There was no invoice included, nor was there a canceled check confirming the payment of $236. Mr. Siegel is a political activist who has been intensely involved in the partisan elections over his entire legal career. His belittling of the political polling and his purposeful portrayal of the poll of only 230 completed calls as almost irrelevant is somewhat, we believe, to be disingenuous. He knows that the polls have a profound effect on the outcome of the election in many ways. Darrell Bricker, the CEO of Ipsos Global Public Affairs, and John Wright, Senior VP Polling, provide a simple blueprint for both conducting a poll and effectiveness in their book. We know what you're thinking. What they've found is, what they say is, we have found over the last many decades is that if you do a survey of 1,000 people randomly chosen, but drawn so as to reflect how the country is populated, then you'll end up with pretty accurate results. If 1,000 subjects can be accurately predicted a trend for Canada, then 230 completed calls in a single ward of the city of Mississauga carry some weight, provided certain fundamentals exist. The poll would need a mix of respondents from two very divergent parts of Ward 5, Malton and Britannia.
Sorry, what's your reference on this text there?
Which one? We're still on tab 5.
Yeah, I know, but what's your reference? Like you're quoting this from the book?
Yes.
Go ahead.
I'm sorry, there's a book that says that a poll needs to have a mix of respondents.
Mr. Siegel, I'll be giving you the opportunity once you finish.
I am objecting to this line of presentation as if it comes from an objective source. These are Mr. Cashin's speculations as to the nature of a poll in this ward. It is not from an independent source.
I hear you. Let them finish. You will have your chance to object.
A base of phone numbers must be purchased or provided in some way so that households in both areas could have been contacted. A much larger pool of calls must be attempted before 230 completed calls have been achieved. From the report provided in tab 5, we can see the Crombie poll was conducted July 18th from time 7 o'clock to 9 o'clock. It showed the 6 names to be tested. Each name brings represented by a first initial as well as a sequential number from 1 to 6 on the phone pad. Only Mrs. Crombie, B1, was not registered at the time of as a candidate in Ward 5. Further, at tab 5, it appears there was a number of completed calls assigned to each of the 6 names being tested and another column denoting the percentage of the predicted votes corresponding to the numbers. 230 calls were completed, but we don't know from the notes provided how they were dispensed over the 2 areas in the ward. Again, we point out the background section, Mr. Siegel's presentation. He agrees a poll was conducted but dismisses its significance with the following comments. The poll was not at all something that was capable of being used in the course of a campaign, and further, it provides no detail beyond the provision of a snapshot of the voter preference in a field of potential candidates markedly different from the list of people who actually ran, and was dubious and we submit that the snapshot provided Mr. Siegel's presentation may not be the full extent of the poll in that 230-person content. And in the estimation of experts referred to later in this presentation, would not usually take 2 hours of automated calls. There are more extensive results that can be achieved in a 2-hour poll, which can lead to the decisions that could shape a campaign and affect the outcome. A decision regarding whether or not to enter the race, a candidate who polled last being convinced to withdraw from the race, acquiring sufficient knowledge of local issues, help formulate a platform for a campaign. It is interesting to note that Mr. Thomas withdrew from the campaign and endorsed Mrs. Crombie on the 5th, 1 month after entering the race. Should the committee conclude a compliance audit be called, we suggest all candidates whose names appear on the survey be questioned as to whether they were asked to participate in any way in its administration, including limited to financial participation. And if the results of the survey were used to induce any to withdraw from the campaign, an infraction under the Act, Section 93E.
I must object to a reference to Section 93E as being part of this. It is not part of the financial reporting requirements under the Act. It is not within the jurisdiction of this committee.
If I could just ask that the comments be held, I will have the same respect for Mr. Siegel. Otherwise,
With respect, I'm trying to restrain, but when an objection needs to be noted for the record to create a record for a potential appeal, I am obligated to make my objection known. Thank you.
it is also interesting to note Mrs. Crombie's first piece of litter presented 10-point platform specific to Ward 5 issues, and the second printing had 2 different covers. One which prominently featured a photo of the mayor for the Britannia area, and the one in Malton community which did not, which is tab 14. Only the chairman has those brochures. We didn't have them.
Tab 14?
Yeah. So you may have to share those.
Sorry, these pic photographs,
Those are just a reference of the materials used.
and what has to do with the locations?
From the polling, information graph from polling. We dispute the cost of the poll, which is characterized by Mr. Siegel as some $236 by referring to several documents in tab 7 from companies specializing in conducting such polls.
Tab 14 is it.
It's on here. Tab 14 is in the end with the photographs.
This is Mrs. Crombie's literature.
have it?
Yeah. No, I know. You're right.
I think everybody should have a copy.
Well, we don't have that many copies, so that's all.
Did they have a photocopy of it?
No, that's all we have. Those are Mrs.
Okay, great. But any submission you provide must be evaluated from the responses and my file codes.
Right.
I understand what you're saying, that these are only color photographs here, right?
Well, those are Mrs. Crombie's actuals.
Just in a nutshell, how do you tie in this with the poll?
Well, we're into that right now. Records notes from the conversation between one of the applicants, which is Mr. Young here, and Jeff from Solus One in the first week of January, in response to a request for a quote on a basic poll of similar parameters that are conducted by Mrs. Crombie. So Solus One suggested the basic setup fee for the poll is $200, plus $500 for the number of calls required for an end result of 230 responses, plus the cost of acquiring a database of phone numbers for the area to be polled. The results estimate was in the range of $1,400 plus tax for a single question response such as that posed in the Crombie poll. It was suggested that more current phone numbers would require a more expensive database. The company was also willing to work with the database provided by the client. So if you go to tab 7, page 2, presents a detailed breakdown of the number of calls that would be required to achieve a result of 230 fully completed calls. This estimate of $1,496.76 included an actual invoice of $818 for the purchase of phone numbers for Ward 5 dated July 27, 2011. The first contact salesperson suggested an actual phoning time of half of what was designated on the Crombie report, or 1 hour time slot. Phone numbers for Ward 5 acquired by means other than a purchase would still require an in-kind market value if entered as a campaign expense. Go to tab 7, page 3, provides a trade price list for automated calls from Solus One that provides the survey package minutes. So to get that price list, you actually have to have a secure code on their webpage and get into their price list. So $650 for 5,000 contacts, $999 for 10,000 contacts. So if you go by the first contact's recommendation of 7,500 numbers, your contact list would cost alone $825. It is reasonable to conclude that a poll conducted on July 18th was not done for a sum of $236 as claimed by Mrs. Crombie and Mr. Siegel. Its cost was considerably more. It is also reasonable to conclude that the cost was misrepresented to the committee on October 25th and bringing into question the credibility of other relevant information regarding Mrs. Crombie's financial returns. In Mr. Siegel's comments under background, we believe he is disingenuous when it includes spending money on a poll that would be as relevant as providing refreshments, paying gasoline, and using a cell phone. However, paying for legal advice in order to ensure that the Act is complied with from the moment the nomination papers are filed, we would agree with. That's because the candidate has now entered the race. And issuing a press release to announce the press conference to be included immediately after the nominations, we would also agree with. Both Mr. Siegel and Mrs. Crombie are seasoned participants in political campaigns. Both are well aware of the cost and effect of polling. In fact, a poll conducted by the Mississauga Streetsville Riding Association, if you go to tab 10, page 4, is also referenced at $1,869 as reported in the audited financial statements.
Sorry, what tab?
Tab 10, page 4.
Page 4. 1869.
Correct. Whereas federal and provincial campaigns permit pre-writ expenditures of this type, municipal campaigns clearly do not. A cursory reading of the Act would reveal this, and the onus is ultimately on the candidate to adhere to the Act. Conducting a poll in advance of registration as a candidate in the municipal election, no matter what the cost, is a clear breach of the Act under the sections represented. Failing to report the true market value of the poll as an election expense is a breach of the Act and following sections.
That's your issue number 2.
Sorry?
That's your issue number 2?
Nope, that's still on issue 1. Further breaches may have occurred in sections 9 and under using influence opponents as well, failing to report the market value of a poll, and failing to include the poll and the candidate's spending limit. It is reasonable to believe that the poll had an impact on the results of the by-election held in Ward 5 on September 19th. A full compliance audit should be a recommendation of the committee based on the concerns we have raised and the evidence we have provided on this matter. Issues 2 and 3.
Can you pause here for a second?
Yep.
There are 6 issues as we have. Do you want me to hear all 6 issues or ask any question about the issues? Each issue? So do you have any question on issue number 1? Any? No? Mr. Chan?
Yes, I have.
On the issue number 1, we will ask a question to clarify.
Based on the information that Mr. Jackson was given, the information I've heard today on the issue that incurring expenses prior to registration, nomination papers were filed in Canada on August 4th, 2011. These expenses which you have just referred to were incurred prior to August 4th, 2011, meaning that she was not a candidate at that time.
Correct.
Second thing is what I would like to hear from you, sir, is that these expenses were incurred prior to campaign, therefore they are not expenses that the alleged breach under section 761, 762 are being referred.
Well, according to the Act, you're not even supposed to spend money on the campaign until you register and before you open a bank account.
Yes.
In federal and provincial elections, you're allowed to do this type of polling. In the municipal, you're not.
Yeah, but these
It's what we
expenses,
believe.
sorry to interrupt you, these expenses, as outlined, were not incurred when she was a candidate, because the candidate was not filed on August 4th, 2001, when these expenses were incurred prior to. What I'd like to hear from you is that to show that these expenses were incurred and used where they were used in the campaign to influence the voters or the opponents in any way, that would constitute an expense under the election campaign. I'd like for you to give me some compelling and credible information to confirm that these expenses, to qualify as an expense in election campaign, were in fact used in the campaign, election campaign of the respondent.
So if I understand your question correctly, you want me to explain to you how the information was used?
That's what you're alleging. You're saying that it was an election expense. I'm saying that to qualify
I didn't say
as an
it was.
expense, I'm asking a question, how was the poll used in the election campaign to qualify as an expense on the election campaign?
Actually, what we are saying is this poll should never have been conducted in the first place until the candidate nominated themselves. In the Election Act, it says they have to nominate themselves. What we're saying, based on the information and calling Solus 1, who was the supplier to Mrs. Crombie, there's no way that that poll could have been done for $230. It cost $200 just to set the poll up. To buy the contacts cost $800. To actually go through the questions. In that time period of 2 hours, you can ask up to 10 questions based on Solus's documentation that we provided in the booklet. So we do not believe that the answers given in the last hearing, as also in the schedule, and the answers that were given in the media previous to that are true and accurate. We have a reasonable belief, based on the research that we did. We don't have the subpoena powers that an auditor does. So we can only do what we did and call for quotes and to see if the information is accurate. All of that being said, the information you get from a poll, as we presented from Ipso Reid, one of the largest people, you can find the direction of how the people in that ward are going before any other candidate knows that that person is in the race. And that's not fair. It's not a level playing field, because if one of us are out doing other polling after we've registered, we wouldn't have the same right or the same privilege of knowing that Mrs. Crombie's in the race to poll and find out how to develop our messaging for the campaign. So it's very valuable information. And I think we've put enough documents in there to disprove the statement that the $230 was for a simple poll, because you can't do that.
I hear you. Just to summary and clarification purposes, and in the previous submission, and I'm sure the respondent will respond to that matter also, you saying that $236 is not the correct amount she could have spent on the poll, and you have supported something close to $1,800, which you also brought our attention, the federal financial statement, which was, I don't know the index, right, that it cost $1,800. So the $236 was she spent personally, and she has admitted that in the media before, and was brought to us in the past also. So the amount is not correct. That's one issue you have. Second, she did not put that in the financial statement. Number three, she conducted that expense on her own and not included as an election expense.
Correct. And one of the issues is if we have, for round figures, a figure of $44,000 to spend in this campaign, if you're spending $1,400, $1,800 outside of the campaign and it doesn't go to your expenses that you're supposed to report and your spending limit, then it gives that person an unfair advantage over the rest of the field. That's why the Municipal Act says you're supposed to keep everything contained in the campaign from the time you start to the time you close.
Any questions? Mr. Brewer?
Let's move on to the issue.
Okay, issue number 2.
We have reason to believe Mrs. Crombie further contravened the Act in Section 7 by using election signs and stakes purchased from or donated by federal and or provincial registered parties and riding associations. We'll be referring to supporting documentation from the various riding associations and campaign statements. So all these that we're going to provide to you were either available on the internet, going to Elections Canada, downloaded, or Mr. Young went out to Scarborough to access the Ontario election ones. In the Act, Section 70 states, for greater certainty and without limitation, the generality of subsection 3, the following shall not make a contribution. A federal political party registered under the Canadian Elections Act, or any federal constituency association or registered candidate of a federal election endorsed by that party. If we go back to our first slide showing the overlap, Mrs. Crombie was actually still a registered candidate of a federal election. A provincial party, constituency association, registered candidate leadership, contestant registered under the Elections Act. At the hearing conducted on the 25th, and the documents presented by Mr. Siegel and Mrs. Crombie, an attempt was made to establish the following. The fact of the matter is that the candidate used leftover signs from her previous 2008 federal election campaign, and these signs were her own personal property, which she was entitled to contribute to her own municipal campaign without limitation. And we disagreed, because they came from a federal party.
Point of order, Mr. Chairman. The hearing that was conducted on October 25th, 2011, was denied, closed the application, has no relevance in the arguments being put forward must be confined to this hearing. We have already dealt with the committee on October 25th, and we should not be reopening any discussion we had then. We should be listening to arguments on this hearing to support allegations in the alleged contravention that we're now hearing.
No problem. So what we disagree with is that a candidate can donate as much as they want without limitation. We do believe there is limitations as outlined in the Act. When you get to the exceptions, the candidates and spouses, you have this a $750 limit for anybody donating to the campaign or corporation. However, a spouse or yourself can donate more money. We do not believe 73 includes material paid for by tax receivable donations made to a registered party, association, or candidate as precluded specifically by Section 70.4. We believe Section 70.4 was introduced into the Act to keep the advantages, both financial and other, of any political politics out of municipal campaigns. There's a federal act, a municipal act, and a provincial act. They're all in silos to keep the politics separate, particularly in municipal politics. They don't want interference from party politics getting into municipal politics. We believe the Municipal Elections Act was carefully crafted and is consistently reviewed and updated to ensure, as much as is possible, all candidates have a fair and equitable opportunity to run a political office at a municipal level. Many inequities exist that cannot be addressed, such as incumbency, name recognition, access to volunteers, availability of donors, and media profile. So those are things you cannot control. We do believe the Act attempts to ameliorate the effects of wealth, political party affiliations, and many other factors that could seriously impact the basic democratic principles that ensure every candidate has a reasonable possibility of achieving elected office in the municipal level. We further request this committee recommend compliance audit based on the issues of the candidates using signs paid for by federal Liberal Party donors in the riding association of Mississauga Streetsville, either for the 2008 general election held October 14, 2008, or for the one held May 2nd, 2011. It is in the public interest to ascertain whether Mrs. Crombie has breached the Act by using materials purchased by partisan donors. We believe the Act is perfectly clear. Without losing sight of 7.4.1 and 2, as an overriding principle, several other facts need to be pursued from statements made. We'll just skip that. However, in media, the candidate does acknowledge the signs were used in the Ward 5 by-election, the federal signs left over from 2008 campaign, and claim that signs were in fact 2008 rather than the recent 2011 general election is based on her comments that they were different graphics. Based on the principle that the signs from both 2008 and 2011 general elections were paid for by partisan donors who received tax credits for those donations is not clear. We therefore acquired and studied all relevant financial returns for the Mississauga Streetsville, covering both time frames, in the hope that the reasons for the distinction being made would become clear to us. We'd first like to draw the committee's attention to financial statements. The auditor's report, Form 4, submitted to the clerk December 16th, tab 3. Turning to page 8, we'll note on Schedule 3, inventory of campaign goods and materials from previous campaign. There are 2 entries.
Page 3?
Sorry?
Page 3, you said?
8.
Schedule.
Tab 3.
Ready? Tab 3, page 8. We maintain that it's reasonable to interpret the schedule as one which intends to list materials carried over from a previous municipal campaign, paid for by municipal donors who do not receive tax credits for those donations, and for the purpose of adding their current fair market value to the expenses of...
Just hold on a second. Page
Yeah.
8, you said, sorry, because my colleagues are not...
Seven of it.
It should be this one here that's actually, I believe,
Sure.
Second to last page.
Yeah, page
Okay,
7.
that's page 7 of 8.
Oh, sorry.
There will be some things in your slide.
Sorry, I'll start. We maintain it's reasonable to interpret the schedule as one which intends to list materials carried over from a previous municipal campaign, paid for by municipal donors who do not receive tax credits for those donations, and for the purpose of adding a current fair market value to the expenses of the current municipal campaign as stipulated under the Act. On Schedule 3, Mrs. Crombie claimed to have 1,000 signs or stakes at 599. There may be a typo in the first document. Per sign totaling $59.99 from her 2008 federal campaign. She's claiming the signs were purchased September 27, 2008 from Lakefront Graphics, tab 8, page 1.
That's the newspaper. Does everybody have it?
We're just going to reference that here.
And what are you trying to do?
Okay, just 1 second. Okay. So these ones, she's claiming the signs were purchased September 27, 2008 from Lakefront Graphics. You'll note the section of signs 2008 featured in the Toronto Sun article that clearly showed the 2008 large coroplast signs. Also shows small signs of the plastic bag variety, which is stretched over thin square wire frames. The large signs were the exact same graphics as the large signs produced by Mrs. Crombie in 2011 and used in Ward 5 by-election with the black Ward 5 stickers applied in the upper left-hand corners to cover the Liberal logo. Also in tab 8, page 2, there's a Chatelaine magazine article which clearly shows a small plastic bag sign printed in Pantone 485, the Liberal color at the time, which was the color used by the and later changed. Tab 8.3. Shows more Crombie signs from 2000, again the smaller signs and the orange red on the plastic bags. Tab 8, page 4. Shows a large Crombie sign from 2008, a large Crombie sign from the Ward 5 by-election, and the new Liberal red used in 2011. So we have signs from the 2008, we have signs from 2011, federal elections, and we have signs from the Ward 5 election. None of these graphics are different, as they were stated publicly before. Here's signs from the corner of Mississauga Road in Eglinton in 2008, same graphics. The Ward 5 sticker put on there using the same graphics. Old red, new red. One was a Justin Trudeau visit in 2009, and then the above National Post article of September 16, 2011. So we previously heard that the absolutely no way were the federal signs in 2011 used in the by-election because the graphics were completely different, and I think we've shown that these graphics are identical no matter what year. In the federal elections they were used, and including the Ward 5 by-election. On tab 8, page 6, there's a photo taken outside the Whitehorn Public School polling station from 2011 campaign. You will note the small signs are coroplast on a heavier metal H-frame, and in the new Liberal red. Two large 2011 federal signs are attached to the fence with cable ties. They are the same graphic designs as 2008 signs, but in the new 2011 red color. These smaller coroplast signs so on tab 8, page 7, shows the small coroplast signs that were used in the 2011 election, also with a black Ward 5 sticker in the upper right corner covering the Liberal logo used in the Ward 5 by-election. They are also in a new red used in 2011 by the federal Liberals. On page 8, tab 8, pages 8 to 13, show you a collection of Ward 5 larger signs, Liberal red with a black Ward 5 sticker covering the Liberal logo. On issues 2 and 3, we're on to the next ones. Sorry. No, we're still on the same one. I apologize. Based on the photographic evidence, it would be reasonable to conclude the graphics for the large signs for the 2008 and 2011 were identical despite claims to the contrary. The 2011 federal and 2011 Ward 5 by-election signs were the same graphics and the same Pantone red color. The smaller plastic bag signs from 2008 were not used in the 2011 Ward 5 by-election. However, the small coroplast signs were used in the 2000 federal election and the 2011 Ward 5 by-election, but not listed in Schedule 3 of the Ward 5 financial statements. H metal frames were used on the small signs in the Ward 5 by-elections, but not listed anywhere on Schedule 3 of the financial returns. Mrs. Crombie declared the value of the federal signs in Schedule 3 of the Ward 5 financial return. She did not list the signs as an item purchased from the Mississauga Streetsville Federal Riding Association. She did not claim the value of the smaller signs nor the H-wire stands required to display them contrary to Section 69. Nor did she claim cable ties, staples, screws, or other miscellaneous hardware. While both count towards spending them, by using federal inventory, there was no need to raise funds, commission artwork, wait for the printing of those signs for the Ward 5 campaign, a distinct advantage over most other candidates. We've included the Section 70 there again, just for your review. 158. For the entire period of the election of Ward 5 from nomination day, August 4th, 2011 to election day, September 19th, Mrs. Crombie was endorsed federal Liberal candidate for Mississauga Streetsville, not having filed her federal returns until November 4th. Further, it remains unclear whether the signs 2008-2011 versions were paid for by the Mississauga Streetsville Federal Liberal Riding Association, by the Mississauga Streetsville election campaigns, or by the official candidate endorsed the Liberal Party, Mississauga Streetsville. Duly audited federal election returns, tab 9 for 2008 and 2011 under tab 12 attached, do not clarify the actual source of the funds used to purchase signs, which were eventually used in the Ward 5 by-election. We have also attached relevant pages from the audited returns for the Mississauga Streetsville Federal Liberal Riding Association for 2008, which is tab 10, and a summary of the Federal Liberal Association for 2008, 2009, 2010 under tab 11, which we will be referring. Okay. We carefully screened the audited returns from the 40th and the 41st general elections, that being 2008, 2011, the Federal Liberal Association returns, any monetary donations that may have been made by Mrs. Crombie or her spouse that could possibly be used as a basis for such a claim. There were none. In fact, Mrs. Crombie's husband made several loans to the Federal Liberal Association for the 40th election, charging the interest of 0.5%, and for the Crombie campaign at $15,000 for her candidate campaign at 12%, which is represented in the tabs. You'll also note in tab 9, page 3 to 7, there were no personal donations made to the 40th general election on the 2008 federal election of the Crombies. Transfer from the riding associations, which is tab 10, pages 4 and 5, and the Liberal Party of Canada tab 10, page 3, were made for the 40th general election campaign for Mrs. Crombie. At tab 11, under expenses, advertising dash other, signs, brochures, ads, etc., there is an entry for $16,909.71. which appear to indicate an order of signs placed and paid for by the Mississauga Streetsville Federal Liberal Association, making them the property of the Riding Association, the value of which were recorded in Mrs. Crombie's 40th election returns, and the grouping of expenses in tab 9, page 1. Under advertising, $20,343.46, paid September 26, 2008. On Schedule 3, tab 3, the 2008 signs Mrs. Crombie claimed to have used in the Ward 5 by-election were listed as purchased September 27, 2008 from Lakefront Graphics. Signs for the 41st general election, which is 2011, tab 12, page 1, were purchased March 25, 2011 by the Mississauga Streetsville Federal Liberal Association in a payment of several invoices clustered in an amount of $30,000, including $16,000 under advertising under the section under which sign purchases would be listed. A careful reading of relevant data, tabs 9 to 12, indicate no personal monies from the candidate or the candidate's spouse were used to purchase signs. All purchases of campaign-related materials, including signs, were made using funds either donated to the Mississauga Streetsville Federal Liberal Riding Association or rebated from the Liberal Party of Canada. Using either the 2008 or the 2011 election signs in the Ward 5 by-election was therefore in direct contravention of the Municipal Elections Act, Section 74(1), accepting signs from a federal political party. Other expenses related to the graphics and designs of election signs, such as the cost listed in tab 12, page 1 for Sherwood Design and Print, in the amount of $857.67, dated March 24, 2011, would have been absorbed by the Liberal campaign or Federal Liberal Association, not claimed as an expense toward a spending limit for the Ward 5 municipal election, contrary to the Act 76(4), failing to include full market value in the candidate's spending limit. Also on Schedule 3, inventory of the campaign goods and materials from previous campaign, there is a notation regarding Bob Delaney's steaks, purchased September 25, 2008, for 90 cents per steak, which gives you a value of $1,800.07.50. Bob Delaney's campaign period income and expense form, which is tab 13, page 2, shows a purchase of $2,836.32 from Cooksville Lumber. Tab 13, page 1, has a notation under Other and indicates sale of signs at $1,841.85, the same amount entered on Schedule 3. Unfortunately, there are no further details provided showing the payment being deposited in either Bob Delaney's campaign account or the Provincial Liberal Riding Association audited statements, which are also available to the committee but not reproduced here. Without a compliance audit, there is no way of knowing if the Mississauga Streetsville Federal Liberal Association purchased the stakes from the Provincial Liberal Association, if the 40th general election campaign made the purchase, or if a candidate, Mrs. Crombie, personally purchased the 2,000 stakes. As seen in the photographs, in tab 8, the stakes used in the Ward 5 by-election were 1 inch by 2 inches by at least 4 feet long. Current market value for 1 by 2 by 4 stake is 78 cents, roughly $1,560 for 2,000. Toward the end of the Ward 5 by-election, there was 1 by 2 by 5 stakes also being used. The current market for value from Cooksville Lumber is 85 cents with tax, or $1,700 for 2,000 stakes. These pictures give you an idea of what was used. The Delaney campaigns commonly used 2 by 2 stakes, 4-foot stakes of those dimensions, which are roughly $1.23 each with tax, or a value of $2,460, not the $1,800. 5-foot stakes would be even more expensive at $36.20 for 2,000 stakes. None of the above costs amount to the $1,800 that was presented in the financial statements. All photos of stakes confirmed they were clean, 1x2 stakes, and none appear to have been used through 3 election campaigns. A 2007 provincial campaign, and 1 or 2 possible federal elections, and then finally in the 2008 by-election. These pictures give you an idea of just a weekend of what happens to the stakes, and these are 2x2, which are much heavier than the 1x2s. Without a compliance audit showing the purchase transaction that saw the 2,000 stakes as inventory of goods and materials from a previous campaign, there's no way of knowing if they're in contravention of Section 70, federal, provincial, or the new stakes purchased but incorrectly reported as Schedule 3 inventory in contravention of the Act 76-4, failing to include the full current market value in a candidate spending limit. Should it be discovered that the stakes were the personal property and donated by Mr. Delaney, accepting his donation would be in contravention of the Act and the spending limit of $750. It is also highly unlikely that Mrs. Crombie purchased the stakes from Mr. Delaney using her own personal funds. In the 40th general election returns, tab 9, page 1, the 4th column down shows Mrs. Crombie's allowable personal expenses as $2,609.22, being reimbursed from the campaign September 1st, 2009. Further, tab 9, page 7, there is a detailed statement concerning personal expenses declared in Part 3A. That shows Mrs. Crombie claiming $165 for transportation to the electoral district, $464.67 for transportation within the electoral district, $53.39 for temporary lodging, $1,779 for meals and incidental expenses, and $200 other personal expenses related to the 2008 campaign. Had the $1,841.85 cost for purchasing the stakes been a personal expense, this would have been the channel through which the expense would have been repaid. In the 41st general election, Mrs. Crombie did not claim any personal expenses at all. Schedule 3 of Mrs. Crombie's Ward 5 returns shows the purchase of Mr. Delaney's stakes taking place September 25, 2008. Transfers of money from the Mississauga Streetsville Federal Liberal Association to Mrs. Crombie's 40th general election campaign, tab 10, page 3, took place on September 26, 2008, and included amounts of $15,000, $8,000, and $15,000. It is highly likely that if stakes were purchased from the Provincial Riding Association, the funds would have come from Federal Association around that time. Unfortunately, there is no clear picture with regard to the transactions that took place regarding the stakes that were used in the Ward 5 Crombie campaign. There are no invoices, canceled checks, and details from either the federal or provincial riding transactions. Only the compliance audit can clarify whether these transactions occurred in several parts of the Municipal Election Act were breached. As mentioned earlier, Mr. Young went to Scarborough to review the statements, but there's no details. They're all held by the riding associations or the candidates. So the average citizen to go and do that work is not possible. And if we want to do the federal ones, we actually have to travel to Ottawa, but only to get the same thing, there's no details. As previously mentioned, Mrs. Crombie was involved in 2 election campaigns.
That's issue 4?
Sorry, issue 4. I apologize.
Mr. Nola, do you have any questions regarding issue number 2? No. What I understand what you're saying here is the fair market valuation of the signs and stakes. You're also alleging that there was a contribution made by the provincial and the federal. Do you have any direct evidence to support your allocation?
I'm not an accountant,
Okay.
but what I can do is tell you that we went through those riding associations. If we understand correctly, Mrs. Crombie said that those 2008 assets were hers. For them to become her property, she would have to buy those from a federal riding association or the federal campaign, in our belief. Mrs. Crombie doesn't become the beneficiary of all the assets from a campaign by osmosis. That federal people got tax receipts for donating to partisan politics. It would, again, make the playing field, whether it's Mrs. Crombie or any other candidate, federal, provincial, any municipal politics, unfair and an unlevel playing field. So we can't track the claims that those signs were paid for. We can't track the claim that those stakes were paid for. So unless there's an actual paper trail, an audit trail, showing how that was paid for, then yes, it's an illegal contribution to the campaign, is what we believe.
Okay, that's by her, because she was a federal candidate also. But you brought the matter of Bob Delaney here.
Yes.
And she reported in her financial statement, Schedule 3 also, that she did have some stakes purchased on 25th of September 2008, both Delaney stake and 90 cents.
Sorry, I didn't hear you, sir.
Sorry, on page 7 of 8, Schedule 3, inventory of the campaign goods and material, stakes. Date acquired 25th of September.
Sorry, you're talking tab?
Tab 3.
Yes.
The financial statement audit report form 4. Page 7 of 8.
Yes.
2 items on the top.
Yes.
This first item, electronic graphics.
Yes.
$5.99.
Right.
The second one, Bob Delaney stakes.
Correct.
At 90 cents, 2,000 stake for $1,807.
Right.
How does it become a provincial contribution?
Because there's, if you go through all the provincial financial statements that we provided, there's absolutely nowhere in there that it says it was paid for.
Paid by?
By Mrs. Crombie, by the federal, Liberal Riding
No,
Association.
you're talking provincial, Bob Delaney.
Right.
Bob Delaney.
So Bob Delaney, from what I understand here, is these stakes were given to this campaign, because it doesn't say that they were bought. It says materials from a previous campaign. It cannot be accepted from a provincial party. It's against the Act.
Yeah, I hear you, Brad, and I read the section of the Act also, regardless of the federal and provincial, who can contribute, who cannot contribute, I'm aware of that. But she brought a value of the inventory. The value from the previous campaign use in the candidate, $7,797.50. And she's valuing 90 cents for 2,000 Bob Delaney's, which was purchased back in 2008.
Right.
I hear you that her campaign started in August 2011, correct? It's 2011, right? So how does this become a provincial contribution or from the Riding Association provincial? That's what I'm trying to fail to understand. Help me here to understand.
No worries. Coming back to the presentation, what this section of the report, what we believe it is relating to, is if you have a previous municipal campaign, like some of the other candidates, Simmer Poor, Carolyn Parrish, or even the Adams, you're allowed to bring, like if you run it, you have signs left over from a municipal campaign. Because
that's what the word implying here you're saying.
Right.
It's a previous campaign, is the
municipal
campaign.
Municipal.
From previous campaign, you're implying it is...
I'm not implying.
Okay.
We believe the Act is implying.
The Act specified is Form 4, and it's talking about the Form 4 financial statement talks about the Ministry of Municipal Affairs of Housing, and it talks about the municipal election.
Correct.
So anything goes here is related to municipal election.
If it's inventory from a previous municipal election. And what this section, does here is levels the playing field. So you've already been in an election, you raised the money 4 years ago, you bought the signs, they want you to bring this back into your new campaign, but at a fair market value. So that this section, all this is meant to do is to level the playing field on fair market value for previous municipal campaign inventory. But it doesn't mean you get stuff free from another campaign, from municipal or provincial.
I understand that. But she brought $7,797 fair market value worth of signs and stakes from a federal or provincial candidate. Herself, she was a federal candidate.
That's what,
Bob Delaney, I just want to clarify, so how does it become a federal and provincial contribution from the federal party or the provincial party?
well, who paid, my question then is, who paid for this?
Let them come back. Okay.
Yeah, I mean, if there's no paper trail, there's no check, canceled check,
Okay.
it's a donation.
I have no further
You can't
questions.
funnel it through.
But is that question stated? It's not, or it's just a question like, the question is.
No, it says here, no, it says here, point number 2, accepting signs and stakes from federal and provincial political parties.
But his question was more payment.
Sorry?
You're saying, your recent question was, you want to hear from them who paid for these signs?
I think what we're trying, the points we're trying,
Yeah, exactly, yeah.
sorry, the points we're trying to make in this presentation is, we've used best efforts to go through all the financial statements, and at no point, and we're not accountants, we're not forensic accountants, at no point do we find a paper trail that would justify that these were paid for.
Here you go. Mr. Chairman?
Mr. Cashin, they reference the financial statements of the respondent, the auditor's report, appended to financial statements, clearly stated that it was not qualified in any way that the report, that the financial statements as submitted by the respondent to him, and which he prepared, they were within the accounting treatment prescribed by the statute 1996, section 76. Based on what you just stated, are you implying that the auditor's report supporting the financial statements were deficient in their report?
I'm sorry, can you
Are
say?
you implying that the auditor's report was not a clean report, that it's calling into question the auditor's report, it was defective or deficient in information, which based on what you have just outlined to us?
Again, I'm going to state that I'm not qualified to make a professional judgment on a licensed accountant. So my statement and our statements as we project in this agreement is, we've used the best of our abilities. We have a reasonable belief that there is no paper trail showing that these signs are paid for by the candidate. And when you refer to this section of the return, all this does is equalize the playing field so that if you've been in a previous municipal election, that you bring whatever inventory you have forward and you put a fair market value so you're subject to the same spending limit as every other candidate. You cannot gain an advantage because you've been in another election. That's what we believe this section is doing. But we do not believe that you can take inventory from a provincial or federal election and bring it in here, and just because you're saying this is the fair market value, contribute to your spending limit, because it has not been paid for by municipal donors. It's been paid for by either, we believe, a federal party, a federal partisan donor that gets a tax receipt up to 75%. And again, that is not a level playing field in municipal politics.
Okay, over here, thank you.
Good point.
No? You can carry on issue number 4.
The battery light continues to blink.
As previously mentioned, Mrs. Crombie was involved in 2 election campaigns which overlapped. Several benefits were realized through this overlap, one of which appears to have been the design and operation of the website, which appears on the 2011 campaign signs, as well as the 2011 Ward 5 municipal signs, the www.bonniecrombie.ca. It is not known if the site was reworked for Ward 5 race, and if so, if there was a fee paid or if it was an in-kind donation from the Mississauga Streetsville Federal Liberal Association. Again, a compliance audit would be the only means available to clearly separate the costs and assign them to the 2 campaigns. So if you refer back to the schedules we provided on the signs in 2008, federal, 2011, federal, they all had the same URL and was never changed for the municipal election. And because that election was still open We believe that that's the use of federal assets, and there was no clean separation before the Ward 5 municipal campaign started. The second website, Vote Crombie, was also a crossover from the 2011 federal election, appearing on pamphlets for the Ward 5 race as well. The phone numbers that appeared on the candidates' Ward 5 municipal pamphlets, it was the only number provided for the campaign, and is a personal cell number attached to the BlackBerry that was used in the 2011 federal campaign, paid by the Mississauga Streets Federal Liberal Association. Then we compared some of the other contestants or candidates in the election and took out the phone and internet usage. And again, one of the disadvantages of this whole system is the fact that things are blocked in. And unfortunately, Mrs. Crombie is on the bad end of this stick. But I think moving forward, things should be changed where it's clear. But until then, we can only go by the information we have. So if we look at Jake Deere, he has 4,400, Coeur is 600, Parrish is 900, and myself is around 733. Mrs. Crombie's phone and internet charges total $159. I raise the question of whether federal resources subsidize those services. A compliance audit is required to ensure that there were no breaches of the Act. Failing to initiate for a specific purpose of municipal election, a new internet/campaign website paid for from the campaign account in Section 70, no related expenses were paid by the Federal Riding Association. Allowing campaign expenses to be paid by non-campaign sources in Section 76.4, failing to include appropriate phone and internet costs in the candidate spending limit. We're on to issue 5.
Can you elaborate more on who is or what is non-campaign sources?
Well,
Your 8.83.
well, that's what we're saying. If I take what other candidates have put down as averages, it seems far below the average of every other candidate. And again, I'm prefacing it by saying a lot of these other candidates, you have to bulk expenses into certain categories, and then sometimes it's left up to what you believe to be the right way to do it. However, what we've proven by the 2008 federal election signs, the 2011 election signs, and the Ward 5 election signs is they're all using the same URL from the federal campaigns. So until that federal campaign was closed out in November 1st, those are the assets of a federal campaign. They should never have been used in a provincial campaign.
Any question, Randy? Mr. John?
Yes. You indicated that you have arrived at your conclusion that Mrs. Crombie, the respondent's telephone internet expenses were below average.
Correct.
And you are speculating that they were paid for by her federal or non-partisan writings. Am I correct?
Sorry, would you mind?
Ask your question. You indicated that Mrs. Crombie, the respondent, average internet and telephone expenses were below average of the comparative to the other candidates. Am I correct?
Correct.
And therefore, you are arriving at this subjective conclusion that it was paid for in the absence of your giving us proof, compelling proof that it was paid for by the partisan writings. Am I correct?
What's your definition of compelling proof? Again, my job here is to bring reasonable belief.
Yes. But you have not.
I don't understand if there's a
You have not shown us.
I think I have. If you look at the 2008, 2011 federal campaign signs, they use the URL www.bonniecrombie.ca. And same with the votecrombie.ca, we believe, was also used in the federal. So those are already paid for, and again, they just osmose into a municipal campaign. You have to separate these expenses and the assets. So I'm not sure what more you need me to show you. When you buy a URL, a website, somebody owns that. Who was the first purchaser? So then, if that was purchased by the Federal Liberal Riding Association, then there has to be a financial transaction transferring the ownership, or IP, the intellectual property of that domain, over to the new campaign. So there has to be a financial track record, or a chain of custody to follow that.
We hear you. And you were saying that these were the federal, when she was a federal candidate, that your website or that domain name was there, has been continued use. Therefore, how can be low expense for the phone and the internet for $159, where comparatively other candidates have higher, and you have shown us the trail of that. So
What I am saying,
we're not here to do an audit here.
no,
We just want to hear
nor can I.
why what you're alleging.
What I'm
And
alleging.
you have walked us through, and we appreciate that, okay, through the slides and through the presentation and documentaries
Yes.
that you have given us. Only the questions are coming just to clarify, so we don't walk away with anything which we should.
Right.
We should know clearly.
So my point coming back is, the same web page was used in 2008, 2011, it never changed, but the signs, all they did was put a Ward 5 sticker in the top left-hand corner to cover the Liberal logo. Well, that URL is still the property of whoever paid for it. And my assumption is, because I don't have auditing rights or subpoena rights, my assumption, a reasonable belief, is that the Federal Liberal Riding Association paid for that, or the federal campaign paid for that.
Okay, we got our answer, thank you. Any further questions? Let's move on. Do you have a question?
No,
Issue number 5.
Okay.
Thank you.
We believe we have presented sufficient grounds for compliance audit based on polling and signing contractions. We believe statements made. So, on the failure to disclose and underreporting of salaries, benefits, honorarium, and professional fees. As a well-connected member of the Liberal Party of Canada, Mrs. Crombie has a long-term relationship with a wide range of professionals who work in the field of communications, advertising, and political advice. If you refer to the financial statements from the both federal campaigns.
What tab is it?
If you go to tab 12, sorry.
Page 12, tab 12.
Tab 12, page 1.
Okay. We have 5 item highlighted in pink.
Yeah, but below that is, if you refer to the Rob Trawortha, worked on both of Mrs. Crombie's.
Dr. Ward, line number 37 and 22.
Correct.
April 25, 2011, June 8, 2011.
Correct.
Okay.
Worked on both the 2008 and the 2011 campaign.
2008.
This is the federal 2008 you're looking at?
I'm looking at tab number 12,
Yep.
page 1,
Yes.
financial report, candidate election campaign return.
Yeah.
Okay, and if I look up number column on the left-hand side, you have highlighted 5 items.
And then just go below, if you're
Go
looking.
below,
We forgot
okay.
to highlight the...
37 and 22nd.
That's
April
correct.
25th and June 8th.
That's correct.
Rob Travarta.
Worked on both campaigns and is currently Mrs. Crombie's executive assistant at the city and formerly of Daisy Communications. If they worked on the campaigns, the Municipal Election Act requires there to be an in-kind donation for that time. So it would seem,
Sorry, I'm lost. Can you just backtrack on a little bit here?
yeah.
What's the
difference between...
You're alleging on issue number 5, failure to disclose and unreporting of salaries, benefit,
Right. The difference...
minority of professional fees.
The difference in the Municipal Act...
And you walked me on tab 13 that Rob worked for her in the federal election, and also the owner of
Not the...
sorry.
I don't believe he's the owner.
So what, Daisy Communication has to do with Rob?
Well, in the Municipal Act, if you make your living at communications like this, you cannot donate it to the municipal candidate. You have to put in a fair market value for that service.
But he can donate, but as long as he gives the fair market value.
As long as it's reported in the, yeah. But again, the issue is we didn't see anything reported, and it is our belief that he did work on the campaign. And
But that the respondent will handle how to
no
answer
problem.
that.
That's fine. Also, Nick Cavalis of Campaign Research, through personal friendship with the Crombie campaign manager, Justin DeCiano, was known to be involved with the Ward 5 campaign. And again, was there a fair market value attached to his efforts on the campaign? After donating $750...
So you're questioning the fair market value here, right?
Well, it wasn't reported at all.
Let the respondent.
Yes, we can deal with that.
Go ahead.
As a well-connected member of the Liberal, After donating $750 personal and $750 corporate to the Crombie campaign, did the printer Paul Gray charge fair market value for an array of glossy and intricate pamphlets, which unfortunately only you have on tab 14, which have been estimated by trade printers to be well over $10,000 for camera-ready, if you provide camera-ready artwork on equivalent stock and color, rather than the reported price for design, artwork, and printing of $7,613. Also, on top of that is the stickers that went over all the campaign signs. Section 63 of the Act stipulates products and services must be charged on the scale of that charge to the public in the market area for similar products.
So just stay on that slide because I'll be asking questions at the same time. Sorry. How did you come up with that estimated by trade printer as well as over 10,000?
We went out and asked different printers what they would charge.
Have you included anything supporting estimate here?
We did not.
Very good.
With several full board wide distributions of campaign literature, it is our belief that Canada Post was involved in some of those deliveries. Again, a compliance audit will ensure Section 66, all subsections were followed and properly evaluating the recording of all contributions. Appropriate records were kept for fair market value of service and products. And records were kept for a fair market value for volunteers using their areas of expertise on the campaign. No goods or services were acquired at less than market value. The true value of all goods and services were reported, and no one exceeded a total personal corporate contribution of $750.
So, let me
and more importantly, that the campaign didn't exceed the allowable spending limit of $44,000.
Issue 5, I think you finished, right?
Pardon me?
Issue 5, you finished already? Okay. Then do you have any questions? Okay, in issue 5,
Yeah.
the item number 7, section 71(1), exceeding a total contribution of $750 per person per candidate per election.
I apologize. Do you mind repeating that?
Issue 5,
Point 7.
7.
What number are you referring to?
Issue 5.
Issue 5.
Yes, what number?
Point
Number
7.
7. This is your submission.
Section
Right,
7.
that sheet.
Oh, on the summary sheet. Sorry.
No, sorry, so not on. And the last paragraph you had there was talking about exceeding total contribution $750 per person per candidate.
Yeah. So if you go to that section tab, sorry, tab 3.
Okay, I see Paul Gray there and Bob.
Page 9.
Yeah, I see on the
or which, the page number, I don't think
And after the list of the,
I counted.
you just counted. Okay, give me a moment, please. I'd like to see what it's talking about.
it's, just to make it simple here,
Correct.
the highlighted one. You look at the highlighted one? So you're leading us at Paul Gray.
I'm sorry, can I see the page? I don't think I have
Right.
that.
But he didn't highlight it, there's only
Yeah.
Well, highlight for the chair only.
Yeah, chairman.
For the chair only.
Oh, right, okay.
So contribution, Bonnie Crombie election campaign period from August 4, 2011 to November 3, 2011. Paul Gray, $750 contribution. And then again, contribution from Union Corporation, Boss Brent, check signatory Paul Gray, $750 Corp. So you're saying that the maximum limit is $750, this person has contributed over the limit.
And we have reason to believe, based on fair market value for all the literature that was printed. that-
Okay, any questions, supplementary question we have? Move on to issue number 6, please.
An extension for filing Ward 5 financial statements was granted on tab 2. Mr. Crombie had ample time to familiarize herself with the requirements of the Act before submitting her financial statements on December 16th. There was an initial compliance audit hearing, which we won't mention. So the Act requires all expenses, whether subject to the spending limit or not, to be reported on the audited financial statement. Such categories as accounting and audit, costs of fundraising functions, voting day parties, and expenses related to compliance audit. We assume such detail is required so that the complete picture of the amount of money raised and the amount of money spent and the amount of money, if any, is to be paid to the clerk at the end of the campaign is clearly evident and open to the public for scrutiny. Section 67 of the Act specifically mandates the reporting of legal expenses associated with compliance audit procedure. This account has not been entered on Mrs. Crombie's financial statements. Many of the possible breaches of the Act discussed in our presentation provide reasonable grounds to a well-informed panel for a compliance audit to be ordered. Should a compliance audit be performed under Section 33 of the Public Inquiries Act, we have reasonable grounds to believe that the audit so ordered will show under the Section 76 that Mrs. Crombie incurred a substantial expense before registering as a candidate and opening the appropriate election bank account. In all probability, it will also show under Section 76(4) of the Act that Ms. Crombie exceeded the allowable expense limit set for the by-election Ward 5, ultimately affecting the result of the election. The conclusion, the Supreme Court of Canada held that to preserve public confidence in the Canadian democracy, it is of great importance that the integrity of the electoral finance regime be preserved. To maintain the integrity of the campaign finance system established in the Municipal Elections Act for Mississauga municipal elections, all candidates for office must completely with both the letter and the spirit of the Act, especially the successful candidate. We therefore submit that a compliance audit of election expenses for the recent Bonnie Crombie campaign of the Ward 5 Council is warranted. All of the above information is respectfully submitted by Mr. Young and myself. Thank you.
Thank you. We heard you. In a summary, overall, do we have any question here? Mr. Chan?
Now, I have a question on issue 6.
Go ahead.
Mr. Kaskin, your issue 6, you indicated that failure to report expenses related to a compliance hearing held on October 25th, 2011. You further indicated that there was a alleged breach according to Section 67, subsection 28-1. Expenses incurred for a compliance audit was not reported. Am I correct?
Correct.
We did not have a compliance audit. We had never had a compliance audit. Until the compliance audit was ordered by Section 81(5), we did not conduct a compliance audit. And we did not grant a compliance audit application request approved.
Are you,
on
sorry,
hearing on October 25th, so it was not a compliance order. So I'm asking, you are alleging that a contravention occurred because the compliance order expense was not reported on the financial statement.
What they're mentioning is the legal fees she paid, although we did not order the audit. There was expense incurred.
There was not fall, my question is that does not fall under the definition of a compliance order.
I'm sorry, are you asking me a question, or?
Yes, I'm asking a question
Okay.
that
I'm not
how
sure
do you
what
get
it
the expenses not reported on section 6728-1 compliance audit expense? We never had a compliance audit expense.
Okay, so that's not the only legal expense that we're talking about, though? We're also talking, there's many references that Mrs. Crombie did get legal advice for this campaign that have not been reported in the financials. That's been reported in the media, but it's nowhere in the financials.
Any further question? Mr. Hill? No. Mr. Luna? No question. Overall, do we have any questions? You have taken almost, it's 9:15 now, and we have to hear the respondent also. I would suggest we take 5 minutes, maybe special, drink some water, washroom, and come back.
5 minutes.
We might not finish at 10 o'clock, so
We have the room beyond 10.
beyond 10.